Thank you very much, Amina. Thank you for inviting me to participate, and above all, the greatest honor to sit on the same panel with the great Raji Sourani, for whom I have the most incredible and unlimited admiration for his courage and his contribution to human rights, both in Palestine but around the world. I'm going to talk about this issue of genocide and its relationship to the ongoing conflict. And in particular, and I think this was on the website, it was promised that I would provide the likely outcome, I think was the term that was used, of the current case at the International Court of Justice filed by South Africa. And I agree, of course, with Raji about this huge, profound contribution that South Africa has made by taking the case, by taking on the responsibility for the case. They've taken the lead globally. They have no direct interest in it, although I don't think we should lose sight of the fact that they have a long history with Israel, going back to the 1960s, when Israel became the most loyal supporter of the apartheid regime in South Africa, and maintained that as one by one the supporters of racist South Africa fell away during the 60s, 70s, and into the 80s. And it was only at the very end they were left with one friend, maybe two, if we include the United Kingdom in the world, and one of them was Israel. The other thing is, of course, South Africa has a long history at the International Court of Justice as well. Some victories, but also a terrible setback in the 1960s that led to really almost the destruction of the International Court of Justice. It lost its credibility throughout the planet, and for many years had no cases at all. One of the astonishing things that's happened, and the case filed by South Africa against Israel is only one piece of this, is a very dramatic turn at the International Court of Justice towards human rights litigation. The court typically deals with rather mundane disputes between states about fishing zones and maritime boundaries and rivers, and these are classic issues of public international law. Occasionally they lead to conflicts, but most of the time they get resolved in one way or another. And that's been the bread and butter of what the International Court of Justice has done for much of its history. But really, only in the last 4 or 5 years do we have this phenomenal turn towards the court by states from different parts of the world, generally acting on issues in which they don't have any direct interest in terms of a material. They're not what we call injured states, but they're states who are turning to the court, like South Africa has done, out of frustration with the political institutions that are supposed to address these issues, like the Human Rights Council and the United Nations General Assembly, and above all, the United Nations Security Council. And so they turn to the International Court of Justice, which is one of the more representative bodies on the planet, actually, judges coming from around the world. I don't want to overstate that, because it's still tilted towards the West. But certainly we have judges from many parts of the world, and that's reflected in their judgments. And the fact, as we've seen in the South Africa versus Israel case, their ability also to reach near unanimity on important issues. And we hope that's going to continue. We're awaiting a very important ruling of the court, I think will be issued in the next 10 days, before the end of next week, what's called the advisory opinion on the occupation of Palestine. And I think we have good reason to be optimistic, but again, I don't want to, I'm nervous about being asked to pronounce myself on the likely outcome of a case, and we may not see the same unanimity among the judges at the court that we've seen and almost come to expect in recent months at the International Court of Justice. There are 4 cases dealing with the Genocide Convention at the International Court of Justice. And just to put that in perspective, there have been, I think, a total of 17 or 18 cases dealing with the Genocide Convention since the court began its existence in 1946. And that may not seem like a big number, but the court has only had about 200 cases in its entire history. So nearly 10% of the cases at the court have dealt with the issue of genocide. 2 of them, currently before the court, concern Palestine. The case filed by South Africa at the end of December of 2023, and the case filed some months later by Nicaragua against Germany, based in part on the Genocide Convention, but based on other international legal obligations as well, including the Geneva Conventions and the customary law of armed conflict. And I think that probably South Africa would have liked to be able to pursue Israel before the court for other violations of public international law, of which there are many attributable to Israel in the last 9 months. But they were blocked because of they might seem technical, certainly to people who are not familiar with the law of the International Court of Justice, obstacles to access to the court because of the reluctance of the majority of states in the world who belong to the court but have refused to accept its general jurisdiction over any issue of international law. And in some cases, and this is the case with Israel, they have declined to accept the general jurisdiction of the court, but they have accepted it in a particular treaty or treaties, and one of them is this famous Genocide Convention. The Genocide Convention was adopted in 1948. It now has 154 states parties, which is actually not that high a number at the United Nations. There are 193 member states of the United Nations, and there are some noticeable gaps, difficult to explain. They don't need to concern us in particular because both South Africa and Israel and Nicaragua and Germany are parties to the Genocide Convention. And there are other states as well who should be looking out. I expect they are. I think they're all nervous that this chink in their armor that was spotted by South Africa and by Nicaragua is going to expand. And there may be more litigation, there may be more cases to come. This will depend to some extent on the messages we get, including next week when we get the advisory opinion on Palestine. It will send signals about the willingness or perhaps the reluctance of the International Court of Justice to tackle these issues. Only time will tell, but we will have an important message in a week or so. I've been following this issue of genocide for more than 30 years. It's been a part of my entire academic career, much of which was spent here in Ireland, but also in Canada, where I come from originally, and more recently in the United Kingdom and in France. In 1993, I was part of a fact-finding mission to Rwanda that studied the ongoing civil war in Rwanda and warned that genocide was possible in that country. And very, very sadly, our forecast turned out to have some reality to it, as everybody knows. The Genocide Convention was used to prosecute the perpetrators of the Rwandan genocide without great difficulty before, in particular, the International Criminal Tribunal for Rwanda. It was a And it only really concerned the state of Rwanda, so it was not something that arose before the International Court of Justice. But when people say, well, the Genocide Convention is not an effective tool, or it's not implemented, or the definition of genocide is not workable, they should bear in mind that there are many, many tens of thousands of people who have gone to jail in Rwanda before the national courts, occasionally before other domestic courts under universal jurisdiction, and also as a result of convictions for genocide by the International Criminal Tribunal for Rwanda. The real laboratory, if you want, though, for understanding this definition of genocide was the International Criminal Tribunal for the former Yugoslavia, followed by the International Court of Justice. And those two institutions are linked, not in a formal sense, they're both UN institutions, but there's no hierarchy between them, at least not in UN law. The International Criminal Tribunal for the former Yugoslavia got there first, because they started prosecuting cases of genocide at the end of the 1990s and in the very first years of this century, and their findings about genocide, their interpretation of the definition of genocide, was then pretty much endorsed by the International Court of Justice when it dealt first with a case filed by Bosnia against Serbia under the Genocide Convention, a judgment that was issued in 2007, and then in a second judgment issued in 2015 in a case filed by Croatia against Serbia that more or less replicated what had been said in the earlier decision dealing with Bosnia. What was the difficulty? The difficulty was distinguishing between what we would call colloquially ethnic cleansing and full-blown physical destruction of a population. And this has been an issue since the Genocide Convention was adopted. In the Bosnia decision in 2007, the International Court of Justice followed the approach taken by the International Criminal Tribunal for the former Yugoslavia and said there's a distinction to be made between the expulsion of people from a territory and their physical extermination. And they say these two notions can overlap. Sometimes we can have both of them together. They're not mutually exclusive, but at the same time, there will be cases we'll have where people are being expelled from a territory, and this suggests that the intention of the perpetrators is not to destroy them physically, but rather to get them to move on, to leave, using violence, persecution in various forms. And that was generally the approach taken, and it led to the International Criminal Tribunal for the former Yugoslavia, followed by the International Court of Justice, adopting a kind of an incoherent approach to the conflict in the former Yugoslavia, where they concluded that there was a single episode of genocide that took place in 1995, the famous Srebrenica massacre, where about 7,000 to 8,000 Bosnian Muslim men were murdered and buried in mass graves. And the more general conflict in the former Yugoslavia, particularly in Bosnia, but also in Croatia, that involved the expulsion of ethnic groups, Croats, Muslims, but also Serbs, from the areas where they had been living historically. It's very interesting that when the court, including the International Court of Justice, adopted this approach, they turned to the debates when the Genocide Convention was being adopted in 1948. And they pointed to the fact that one of the member states of the United Nations in 1948, in the General Assembly, had proposed an additional act of genocide to be added to the convention, which was the expulsion of a people from its historic territory. And that was voted down. The state that proposed it was Syria. What was Syria thinking in 1948. Syria was talking about the Nakba in 1948, and they wanted to include it in the Genocide Convention. And the Western states opposed that, not because they had any great position on what had happened in the Middle East, but because they themselves had been involved in the expulsion of ethnic Germans from parts of Central and Eastern Europe following the Second World War. Perhaps 11 to 12 million ethnic Germans were expelled from parts of Poland, Hungary, and what was then Czechoslovakia. All of this just, to point out, and Palestine did this in its recent application to intervene in the South African case at the International Court of Justice, that while Palestine was not a member state of the United Nations in 1948, that the issues about Palestine and Palestinians and their suffering over all of these, over this entire century, really, were not far from the negotiation of the Genocide Convention in 1948. When the court, the International Court of Justice, ruled in the Bosnia case in 2007, they rejected the claim that Serbia was responsible for genocide in Bosnia. Even the massacre in Srebrenica, they said, was not the work of the Serbs, but rather of the Bosnian Serbs, who were separate and distinct and autonomous. And so they let Serbia off the hook on that issue. But I think, in a way, in order to sugarcoat the pill, the bitter pill that they were proposing in the judgment, they found that Serbia had violated the Genocide Convention by its failure to prevent genocide in Bosnia. And they said, you're not responsible for committing it, but you had a duty to prevent it taking place, and you were in a position to do so. You were in a position to do so because of the influence that you had over the Serbs in Bosnia. This is not something that is really set out clearly in the Genocide Convention. It uses the word prevent, says that there's an obligation to prevent genocide, but it doesn't really go beyond that and provide any detail about what that means. And so the International Court of Justice in 2007 was being very creative in exploring this notion of the prevention of genocide. And they said that there was a duty to prevent genocide where there was not where you can prove genocide took place, but where there's a serious risk of genocide taking place. That's the test. It's a lower threshold. It's easier to establish a serious risk than that the crime has actually been committed. And they set that out, this principle, that there was if there's a serious risk, then there's an obligation to take measures, lawful measures. Nobody wanted Serbia to send the army into Bosnia and Herzegovina, but to use your political influence and various means you have of influencing those who are the source of that serious risk of genocide. And so today there are many candidates for that serious risk, many candidates of states that have an obligation under the Genocide Convention to prevent genocide and who are seeing all of the signs of genocide being committed, certainly enough signs to say there's a serious risk. And while the International Court of Justice, in its 3 orders of provisional measures that it's issued now since January of this year, has not used the term serious risk, because that's not the standard that it's applying when it imposes an order of provisional measures, there's no doubt that those judgments, those 3 orders of the court, send a clear message of a serious risk of genocide taking place. That's the basis, really, of the case that's been filed by Nicaragua. Nicaragua, I hear rumors that Nicaragua may be thinking of a few other candidates to go after at the court as well. Time will tell on that. So what is the prospect for the case, the main case? I think others are going to speak in a little more detail about how all of this will unfold. The court imposed a requirement on South Africa that it make its formal submissions by no later than, I think, the 24th of October of this year, what we call the memorial South Africa. People have been asking and been saying, how strong is the case? How strong is South Africa's case? Well, we don't know how strong it is because we haven't seen it yet. We'll see it, or at least the court will see it in October. You should know as well that for some bizarre historic reasons, the court doesn't make these proceedings public until you get to the oral hearing, which will be 2 or 3 years down the line. So you won't find the South African memorial on the internet. At least you shouldn't be able to find it. Maybe if you have a friend on the South African delegation, you'll be able to get sight of it, what the submission is. Then the likelihood is that Israel is going to object to that proceeding, and they will challenge it on the grounds of jurisdiction and admissibility. South Africa will reply. There will be a hearing in 2025. Israel will lose. South Africa will then continue. Israel will have to file its counter-memorial, and that will take us to early 2026. And then maybe the court will set a date for a hearing at the end of 2026 or 2027. But in the meantime, we're going to have another genocide judgment, probably. This is the case of Gambia versus Myanmar, filed in 2019. And the Gambia versus Myanmar case is, again, similar in many respects, I think, to the two Yugoslavia cases. If the court follows the approach it took in the Bosnia and Serbia cases, and says, no, this was more a case of ethnic cleansing than of genocide, well, then if they follow that, Myanmar will win and Gambia will lose. That's if they follow their past precedent. But the court is in a state of change, of evolution, and it's also being urged to take a more generous and liberal approach to the definition of genocide. In the case of Gambia versus Myanmar, last November, at the beginning of November, 6 Western states, Canada, UK, France, Germany, Netherlands, Denmark, all filed what we call an intervention in the case. And this is one of the other fascinating developments in genocide law in the last 3 years. There are now about 50 states that in one way or another have taken a position on the definition of genocide before the International Court of Justice. Completely unprecedented. This has never happened before. And the 6 Western states said to the court, you should follow a dissenting judge, the Brazilian judge, in 2015, who said, you're making it too hard to prove the intent to commit genocide. You have to make it easier to prove that genocide is being committed. You have to look at other factors that may be taking place that suggest genocidal intent, like forced displacement within a territory, and excessive numbers of casualties and persecution of children. Now, I don't think the lawyers in London and in Berlin and in Ottawa were thinking that there might be a case filed against Israel at the International Court of Justice when they wrote that opinion. And I think if they had been able to anticipate it, they wouldn't have done it. They shot themselves in the foot. They scored an own goal at the International Court of Justice. But all of this is to say that there is a turbulence in the understanding of genocide that may result in a much more expansive approach to the proof of genocidal intent at the International Court of Justice. I expect the judges are going to take this step cautiously. I don't see them opening up the notion of genocide to cover what we call cultural genocide, where languages are forbidden or where museums are destroyed, those types of issues. I think that's probably a step that's way too far. But making it easier to make proof of the genocidal intent, the intent to destroy, by looking at conduct like that of Israel in Gaza in the last 9 months, I think is quite a reasonable expectation of the court. The court's composition changes. By the time we get to the merits on both the Myanmar case and the Israel case, rather the Gambia and South Africa cases, in 2 or 3 years, I don't think there'll be any of the judges who were there in 2015. So the judges are changing, and there's more and more pressure from states. And I say this, maybe pressure is the wrong word, because what I really mean to say is that the views of what states think the Genocide Convention means are important to the court. It's not a matter of, some people thought, you know, the US Department of State calling up the American judge and telling her how to vote. I don't think that, personally, I don't think that goes on, or if it does, I don't think it's widespread. It's not the way people think of it and thought of it back in January when they said, well, how did this happen that the American judge voted for the order of provisional measures? The judges at the International Court of Justice are in principle independent and impartial, and most of them display that. But they are also influenced by their origins, by their political culture, their legal culture. This is normal, this is inevitable, and just as we will not be surprised if the judge of the United States, the American judge, or the German judge are, you know, tilted a little bit towards Israel. We're also not going to be terribly surprised if the South African judge, great Judge Deirdre Clady, is tilted a little bit in the other direction. So we'll see some of that. But all of this means that the likely outcome, yes, I think the likely outcome is a successful case by South Africa, but one that is going to depend on this evolution. And, you know, when we get the judgment in the Myanmar case, it will indicate where this is going to go at the International Court of Justice. Great developments in that court. Mohammed referred earlier to the International Criminal Court and the disappointment that so many of us have felt, not just about the court's performance in general, which I think has been, for a variety of reasons, unimpressive, very unimpressive. But there are many explanations for this, and it certainly is harder to have an international criminal court with general jurisdiction than it is when you have a targeted court like the one for Yugoslavia and Rwanda. But also with considerable disappointment with the leadership that should have been provided at the International Criminal Court by the prosecutor. And it was in a modest, patient way by Fatou Bensouda, the second prosecutor at the court. And her, willingness to proceed with the situation in Palestine stands in real contrast to the strange and unenthusiastic conduct of the current prosecutor. And I agree also with Rajiv Sarani, his final remarks about the strange approach now being taken by the prosecutor to seeking arrest warrants, announcing ahead of time that he was seeking them rather than doing what they normally do, which is go quietly before the judges, because it's supposed to be a process between the prosecutor and the judges of the pretrial chamber. And he made it public, and then that opened up, strangely, the government of the country that Karim Khan comes from made an application to intervene, which has never happened before, and astonishingly as well, the judges of the pretrial chamber agreed and allowed that. This is a very disturbing thing, but listen, this is we didn't have great expectations for the International Criminal Court until a few months ago, and maybe our enthusiasm for the most recent developments was misplaced and a little over-enthusiastic. That being said, the main act in The Hague is at the International Court of Justice, and it's built around the Genocide Convention. Thank you very much.